I'm going to get started. Again, welcome. Thank you for joining our Watershed Institute's Technical Friday. Today's webinar is U.S. Supreme Court Reversals, New Jersey Impacts, which we will try to describe and explore today. All right, if you're not familiar with the Watershed Institute, our mission is keeping water clean, safe, and healthy, and we work to restore our waters and natural environment in central New Jersey through conservation, advocacy, science, and education. Our Technical Friday webinar series is a series we started to provide additional higher level discussions with engineers, attorneys, planners, elected officials, environmental advocates. So thank you for joining. Some webinar logistics, because we have a lot to cover today. I think it was probably about 1,000 pages of reading between the cases. We are recording it. We will send out the recording to those who have registered. We will provide a copy of the slides. And you have a question, please use the question and answer feature of Zoom. We will be monitoring that. Generally, we keep questions to the end, but if I see a question that really begs to be answered, we will do that. If you are an attorney, we are going to provide continuing legal education classes you must attend for the entire webinar. We will be providing a code or codes during this webinar. Please write those down, put them in the verification form, and return it to us. If you don't return the verification form, we cannot give you credits, and then within 30 days or so, we will be providing the certificate of attendance. All right, I must briefly introduce our speakers. Michael Sinkevich is a shareholder with Lieberman, Blecker, and Sinkevich, where he practices environmental law and litigation. He is also the chair of the environmental law section of the New Jersey State Bar Association and has taught at multiple continuing legal education classes. His full bio is there, and we even have a larger one, I believe, on our website. I am Mike Pisauro. I am the policy director here for the Watershed Institute and an attorney. And I have done litigation, land use, and government affairs or lobbying. So we have a lot. We're going to cram it all in. Here are the cases we are going to review. Loper, and I'm going to butcher, Jarsky, Corner Post, and Sackett. And then we will take questions and answers at the end. All right, so, before we start, I think Mike and I were talking yesterday on these cases, and I think there's really a theme running through all of these cases, whether it is Loper, Jarsky, Corner Post, Sackett, and probably many, many more. The majority of the U.S. Supreme Court at this point has a disdain for the administrative state, feels to some extent that it has gone too far. And these cases and probably some others are an attempt to sort of roll it back. And I believe one of the concurring opinions sort of sums some of this up. Sophisticated entities and their lawyers may be able to keep pace with rule changes affecting their rights and responsibilities. They may be able to lobby for new reasonable agency interpretations and even capture the agencies that issue them, but ordinary people can do none of these things. They are the ones who suffer the worst kind of regulatory whiplash that Chevron invites. I believe that was Justice Gorsuch's concurring opinion, but there's this disdain again for the administrative state, as well as sort of the court belief that they are standing up for the little person. I was trying to find a quote that I swear is in Sackett talking about the regular person should be able to stand out on his or her land and determine what is a wetland, what is a water of the United States, and not have to go through a huge regulatory process to figure that out. I don't know, Mike, if you have any other initial thoughts before we sort of jump into Loper?
Yeah, no, I mean, I think you summed up. First off, thank you for having me. The Watershed Institute is an amazing organization, and I'm thrilled to be able to help out and be a part of this. And no, I think you summed it up perfectly. I think these cases, particularly the three from this year, really show the justices, particularly the six conservative justices, um, disdain for administrative law. And there's just no other way to say it. And when we talk, and then you can see the other three justices in a lot of their dissenting opinions explaining that they feel that that's exactly what's happening. That there's six justices that just don't like this administrative way of things, and these cases really attack at that procedure. So I think with that, yeah, why don't we start with Loper? I mean, clearly well, maybe not the biggest, but the biggest case of all of these and the most notorious, if you will.
Yes. All right. So I'm going to take Loper Bright Enterprises versus Raimondo, Secretary of State. And there was also a companion case, Relentless. Um, but brief facts. Um, there was an Atlantic herring commercial fisheries. Um, bunch of fishery in businesses challenged the National Marine Fisheries Services rule that required companies to pay for observers. Um, the Magnuson-Stevens Fishery Conservation and Management Act requires councils to develop plans, and those plans could prescribe additional conditions, requirements, et cetera, to make sure that catch limits and other requirements are being complied with. Um, And so there was a 2013 plan amendment that required the companies to pay for observers to be on the boats while they are fishing to make sure that these things are being complied with. And so really the issue, does the Magnuson-Stevens Act authorize the agency to require the communities to pay for the observers? But the big takeaway is the agency's interpretation of their statutes entitled to deference? Does Chevron continue to live? And just very quickly, Chevron has been around since 1984. It has sort of woven itself into administrative law since 1984. And very basic, when the court does their Chevron deference analysis, is the statute clear and unambiguous? Is it very clear what Congress wanted and what they're directing? If so, we don't go to step two. The statute is the statute, the court interprets it, and the agency really isn't given much deference. Now, if that statute is unclear or ambiguous, then you go to step two. Is the agency interpretation a permissible construction of the statute? If so, the agency is given deference and their interpretation is binding and is upheld by the court. And over the years, the Chevron has sort of been morphed, and there's a step zero, but this is the big picture. And in Chevron, really, and Justice Scalia wrote the opinion, which is kind of interesting because Justice Scalia over the later years became not as much in favor of the administrative state, but noted, the power of an administrative agency requires the formulation of policy. Um, Judges are not experts in the field, and they're not part of the political process. So when dealing with these things, there has to be a reconciliation of competing political interests. Um, what is the executive branch? What is Congress trying to accomplish? What are those policies? And the judges don't get to insert their personal policy preferences into the decision. And that's sort of why Chevron came to be. But unsurprisingly, because the U.S. Supreme Court has been telegraphing the demise of Chevron for years, the court found that the statute did not authorize regulated communities to pay for, at least for the Atlantic herring um, observers, and the agency gets no deference. Their interpretation, the courts aren't bound to be controlled by. Again, not a surprising decision from this court given um, what it has telegraphed over the years. And sort of they came up with that through a couple different things. One is, in the majority's interpretation, the Constitution assigns to the federal judiciary all cases and controversies. So it is the sole role of the courts in the separation of powers. Um, Congress writes the laws, the executive or the president and its agencies carries out those laws, and then the courts tell everyone what those laws mean. So there's a really big separation of powers and sort of I almost want to say lamenting that the courts have sort of succeeded or loosened its grip on its role of interpreting statutes to the agencies. And then there was, cite to the Administrative Procedures Act, which predates Chevron, predates a lot of environmental laws at least. Um, that gives very explicitly the reviewing court shall decide all relevant questions of law, interpret constitutional and statutory provisions. Um, so in the mind of the majority, those two factors sort of weighed and decided Chevron had to die. There was also a lot of discussion in that case that Chevron was really unworkable. And courts really haven't been following that for years. What is unambiguous? What judge finds to be unambiguous, another judge would find to be ambiguous. So there was a lot of discussion in the case that, well, it was unworkable. No one knew what Chevron really meant and how to apply it, and it was very, very subjective. So instead of trying to provide clear guidance, which the court should have been, in my opinion, doing over the years, how to determine ambiguous, unambiguous statutes. They threw the whole thing out and went back to pre-Chevron. And I'm not even sure they went back to pre-Chevron, where the courts will interpret. Pre-Chevron, there was, I don't want to say deference, but the weight given to an agency's interpretation and expectation was considered, but it really wasn't, there's no deference. We're not bound by those determinations. So going forward, it's going to be really interesting to see from a federal perspective what the Supreme Court does with agency regulations. In their interpretation of ambiguous statutes. Are they given any weight or they're not given weight? Reading Justice Gorsuch's opinion, it was kind of interesting because the other aspect of this case, which we're not really going to go too deeply into, is stare decisis. The court is bound by its prior decisions. Because if every decision is different and every decision isn't based upon a previous precedent, there is no, I don't know, law, so to speak. And Gorsuch, in his opinion, in trying to explain why we weren't, stare decisis and Chevron didn't really apply, goes through this process of there is one right answer to a case or a statute and its meaning. And only through multiple decisions, multiple opinions do we get there. And then that is what the law means, which then through this process of multiple cases becomes immutable. And I think that really becomes interesting, because if we finally become, this is what a statute means, this is what the regulations have to say, we then take out of the process, administrations changing and having different um, priorities and different policies to achieve those goals. Are we going to be more carrot, less stick, or more um, sticks and less carrots? So I think that's going to be interesting, and will be interesting to see what these all turn out to mean over the years. Um, New Jersey impacts, I don't know, will be as significant. I think the demise of Chevron on the federal level will have less impact in New Jersey. Yes, New Jersey's environmental programs, at least, we've assumed a lot of the federal responsibilities, but we have a very strong history of cases, actually going back to, I think it was 1978, of giving deference to the agencies. So, 1980 case, courts presume agency regulations are valid and reasonable. That presumption is particularly appropriate where the agency has been delegated discretion and has the specialized knowledge and technical expertise. And then the hurdle is, if you're challenging an agency statute or regulation, um, agency regulation, not a statute, the challenger must demonstrate that those regulations are arbitrary and capricious. Ultra vires would be also, there's just no way to read that statute in that way. You're completely going against it. But the presumption is these things are valid, and the agency has that deference. Again, under the discussion, that theory that the agencies have the expertise, they have been delegated the authority. Very rarely do statutes really set forth really specific details. They usually speak in general terms. We shall restore our waters so that they are, healthy and provide water quality for drinking water. And very rarely do they really go into the details. And if you think about current Congress, um, imagining statutes coming out of this Congress that really provide specifics and how to go about doing things, I think that is sort of not going to happen anytime soon. Now, saying all this, that probably is not going to have a huge impact in New Jersey. I'm going to put a caveat out there. Um, and I'm not sure this situation actually exists. I haven't really gone through every New Jersey register ever. But when New Jersey are proposing regulations, and those regulations use as a justification a regulation by federal agencies in their interpretation, there's where I think there may be some impacts. So the federal government and its interpretation of a regulation sets out a standard or a regulation. And New Jersey, in promulgating their own regulations, referenced and say, we are doing this because section 42 of the Clean Water Act's EPA's regulations say this. That interpretation then gets thrown out, and New Jersey hasn't provided its own rationale, its own justification for that regulation. That's sort of where there may be some Chevron impacts. So to the extent New Jersey is going forward with regulations, the justification shouldn't just really rely on federal standards. It should really set its own things. And then I'm going to tee up one other issue from Chevron, and which will sort of be important later. Chevron specifically said not Chevron, Loper specifically said the death of Chevron doesn't undo all decisions, all upholding of regulations based upon Chevron. it will be a case by case determination. Um, I think that might really come in later. But big picture, Chevron, here's where we are. Mike, I don't know if you have any additional thoughts on Loper, Chevron, and New Jersey.
Yeah, just a couple of comments. First, with your caveat, and it's something I was just thinking about when it popped up. My recollection, I don't do a lot of air quality, clean air. New Jersey, I think it's called, I don't even remember what the law is called, but the New Jersey Clean Air Act, whatever it is.
Mm-hmm.
But my recollection is New Jersey relies a lot on federal Clean Air Act regulation in their law. Similar, I know, with a lot of our hazardous waste stuff, we rely a lot on the RCRA regulations. So I wonder, that might be an open. I mean, a lot of those regulations are very scientific and not overly interpretive, but uh, but that may be one of those potential impacts, I guess. Um, if a interpretation of DEP's interpretation of something gets in front of a court in New Jersey. I did find at least one case when we were getting ready where I know the appellate division, um, it was from 10 years ago or whatever, but the appellate division applied Chevron deference because the pertinent DEP or pertinent New Jersey agency was relying on a regulation from the Federal Health and Human Services. So that was when, and then, it was just like we apply Chevron deference. They cited like 10 cases and then they just moved on. Um, so I think in general, one of the things that you said, well, there's two comments that you made. First, that we saw this coming a long ways away. And it's true. I mean, I remember when Justice Gorsuch was getting appointed to the Supreme Court, that was one of his big things was his hatred, for lack of a better word, of Chevron deference. And it's funny and ironic because the Chevron case was a case in 1984, 3-4, and it was about a EPA interpretation of the Clean Air Act. And it was, I think, the EPA had, during the Carter administration, had more of a, any change in a your addition to the air from a factory would be regulated under the Clean Air Act, where the Reagan administration changed it and made it so that it would only apply to like a full plant. You would have to look at a full plant, not just like one point source. So it was I guess less environmentally protective. And NRDC challenged the EPA's interpretation. Chevron was also involved. I guess it must have been their plant. And Chevron won. The only reason I'm saying all of this is because Neil Gorsuch's mom was the administrator of the EPA at the time, which is just like a funny, weird circle of life where like she technically won the Chevron deference case that he wanted to overturn. Now, of course, she was just as conservative as he is, so I'm sure she wasn't upset by it, but I think it's just funny.
Yeah. You know what? I think, and I probably should have started off with that. Chevron was a shield against arguably reducing environmental protections
Right.
in a challenge. Loper is arguably going to be a shield um, to, we've used Chevron over the years to protect environmental protections.
Right.
So if you have an agency that is viewed as being pro-environment and strengthening those regulations, Chevron deference was useful. Uh, if you have an agency that wants to do all of that, um, maybe not as useful. And so um, it will be interesting.
Yeah, yeah. And
Mm.
and then I guess my last comment before I move on, I know we got a lot to talk about. Your comment about stare decisis, that's like a good, interesting theme throughout a lot of these cases too, because, you know, whatever every group of justices, whether you're conservative or liberal, always says that you got to follow stare decisis, and it's important. That's the whole way the system works. But then whatever group is changing case law, they never really follow it. Like it's some weird convoluted way that and that happens in the next case we're going to talk about too, where there's some convoluted way in which they justify everything, but like if you step back, it doesn't really make any sense. And then the dissenting opinions always complain about it. It's funny. It's
Yeah.
interesting.
Yeah, I mean, the majority took a huge swipe at Chevron as being a very poorly decided case, poorly reasoned case that didn't have a unanimous court.
Right.
Interesting, Scalia was the one who wrote it.
Yeah.
Uh, but yep, let us move on.
Sounds good.
And with all of these cases, it's going to be one of those things that uh, it will take multiple years for us to figure out what everything really means and how this all shakes out. Um,
All
well,
right.
oh, you know what, Mike, before you go, for
Yeah.
those attorneys, here is your first code, 1972, 1972. Bonus points for anyone who can explain why I use 1972. All right, Mike.
I got that one, I think. But uh so the second case we're going to talk about was decided around the same time, June 27th of 2024. And it is the SEC versus, I can't possibly say the name of the defendant. I don't know why, but it's Jakarsi. So I'm going to screw it up the whole time. I apologize, but I'll do my best. And this was an interesting case when Mike approached me about doing this program and we spoke about the cases. This is one that I had not really thought about, had really never dove into. And then when I read it, it was one that I kind of found the most interesting. Yeah, it's somewhat single issue related, but I thought it was interesting. So this is a case. I'm sort of foreshadowing what it's about when you see a jury box here, a photo of a jury box. But this is a case that was decided along party lines. It was a 6-3 decision with Justice Roberts writing the majority opinion and Justice Sotomayor writing a pretty scathing dissenting opinion. Um, I don't read a lot of Supreme Court cases, I'll be honest, but I find that, obviously each justice has their own style. And Justice Roberts seems to me, and maybe I'm wrong, maybe it just happens to be the few I've read, seems to be the most like matter of fact and not overly um I don't know what the terms I'm using, but doesn't use pejorative language as much as some of the others. But anyway, with that said, the hopefully this works. Give me 1 second. I'm trying to well, I can keep talking. Here we are.
Yeah, yeah.
So I wanted to talk. This is a little odd in the second slide, but it's going to sort of frames what we're going to be talking about later with impacts to New Jersey. And what it was is in New Jersey, for administrative decisions, as many of you are probably aware, uh, you have an opportunity in a lot of instances to request an administrative or adjudicatory hearing. That request is, and that's generally when, in general, the times that occurs is when you're, issued an enforcement document from the DEP, which is what we'll talk about today since we do environmental law. There's an opportunity to request a hearing. Also, if you have a permit denial, there's an opportunity to request a hearing. Those hearings go in front of a quote unquote independent administrative law judge. Now, those judges are appointed. They're not Article 3 judges, if you will. And what they do is but they are independent. They're out of the Office of Administrative Law, and they render what's called initial decisions. And the cases, while the cases are technically adjudicated based on like the administrative record, The good part of, AL case, whenever I have a client in a situation where I want to, I always want to request a hearing if we're challenging the enforcement action is, you have the ability to put up witnesses at a hearing, to take some discovery. Sometimes you can even get expert reports entered into the record. So it just sort of allows for like a further fact-finding situation. But the difficult part to explain to any client is while the ALJ renders the initial decision, the head of the agency, so for example, the commissioner of the Department of Environmental Protection, gets to review it and decide whether he adopts it, rejects it, or modifies it. So, in other words, in DEP enforcement action, for example, while it gets adjudicated before an ALJ, the DEP itself has the ultimate decision. And that sort of frames the the underpinning of Jakarsi, which is that it's an SEC decision, and it related to when the slide pops up. I'll get there, but really, what we had the background of the case is the SEC issued an administrative enforcement document against Mr. Jakarsi and his investment advisor firm. Uh, I assume this document, I didn't actually find it. I was actually searching for it earlier this morning, but I assume, it's similar to presumably a DEP enforcement document where it alleges various violations. In this situation, where there were anti-fraud provisions of, the Securities Act, the Securities Exchange Act, and the Investment Advisors Act, three laws that I have never heard of, let alone dove into. But the SEC instituted an enforcement action. And the first thing that occurred is Jakarsi did a collateral challenge, which is what this all ended up being. The issue ended up coming to the Supreme Court, but he challenged in federal court this administrative proceeding, whether it was legal. That was thrown out, and it ultimately went through the normal course of how the SEC always does these, where an administrative law judge reviewed the case, found that Jakarsi committed securities fraud, and the SEC, just like the DEP in a state in New Jersey, like I mentioned before, the SEC affirmed the decision, and the result was Jakarsi was hit with civil penalties, disgorgement, cease and desist orders, and industry bars. So a wide range of penalties were rendered against him. So what happened next was Jakarsi appeals this decision to the Fifth Circuit, and the Fifth Circuit held that in-house adjudication of anti-fraud claims where the SEC seeks civil penalties actually violates multiple constitutional provisions. Um, the Supreme Court ends up granting certiorari, and the decision that the Supreme Court makes is that they rely on, and you'll see it in the slides in a second when they move forward, but they rely on the Seventh Amendment of the Constitution. And the Seventh Amendment of the Constitution, as some may recall, the lawyers on this seminar may remember from law school, that it's a fundamental guarantee of the right of a jury trial for quote unquote suits at common law. So that's what the Constitution says. But then over time, just like everything else that we've discussed and that happens in Supreme Court case law, there was a case law exception to Article 3 jurisdiction, meaning certain cases that don't have to go in front of the judiciary branch, called the public rights exception. And it's a situation in which Congress can assign certain matters to agencies for adjudication, even though no jury trial would be provided. And as I mentioned, this has been developed through case law. It has a very long history, and it became sort of the second prong of what this case was about. So what the Supreme Court's decision really centers around is they say suits at common law include statutory claims that are quote unquote legal in nature. And then to make this determination, the court said they have to do is you look at the cause of action and does it resemble a common law cause of action? And is the remedy the sort that you would traditionally get in a court of law? So, what the court did in this case is they really focused on, as you saw at a previous slide, Jakarsi was, not only hit with civil penalties, but also he was barred from the industry. There was, some other disgorgement of funds, but the Supreme Court themselves really focused on the civil penalties part of it. And they found that civil penalties is monetary relief, and that's what you get in a court of law and a civil court of law. And really, the whole thing is designed to punish or deter the wrongdoer. It's a type of remedy that common law, that, in general, historically, would be a common law remedy that would be enforced in courts of law. So they said that. Then the second thing they said is, look, we're talking about federal securities fraud. We're talking about fraud. Fraud is common law fraud. They're really analogous, even though, and of course, even though there's different elements, different standards of proof, they say, well, they're kind of the same thing. They're really essentially just fraud. So, in moving forward, once they've decided, okay, this is, the type of common law claim that would be afforded a jury trial under the Seventh Amendment, the court then looked to the public rights exception. Again, something that I wasn't overly familiar with before I started reviewing this case and preparing for today. But the public rights exception, as I mentioned a moment ago, is a situation. So it's a quote from the case. It says, our courts governing the public rights exception have not always spoken in precise terms. And then the Roberts goes on to say, the court has definitely not explained the distinction between public and private rights. And they declined to do so in this case too. So in an effort to get around stare decisis, in an effort to get around the public rights doctrine, the court says, look, this is a case, the suit is a nature of a case in an action in common law. The matter is presumptively concerns private rights if it's a matter that's typically a common law case. And therefore, because it's private rights, and we've never really decided the distinction between public rights and private rights, we're going to say the public rights doctrine doesn't apply, and period. Now, the question that was raised, or the way they try to work around one big issue, was there's a case from 1977 called Atlas Roofing versus the Occupational Safety and Health Review Commission. It's a Supreme Court case from 1977. And that was a case that was very similar to this. It was a civil penalties claim case in an administrative proceeding. And the question was that allowed to go forward in an administrative proceeding? Well, the way that this court distinguished that case, because in that case they said, yes, OSHA case could be decided in an administrative proceeding. And the way they got around it is they said, well, OSHA claims were quote unquote unknown to common law, and they contained highly detailed safety regulations. So therefore, that's different than this case here when we're just talking about fraud, which, if you're me and you're a little skeptical of the Jakarsi decision, I look at this and say, well, I'm pretty positive securities regulations are highly detailed, and I'm not positive they were known to common law either. So this distinction is strange to me, but that's the way they get around it. So at the end of the day, I'm sorry these slides aren't moving forward,
Yeah.
but at the end of the day, the holding in Jakarsi was that Jakarsi was entitled to a jury trial in front of a federal court, in front of an Article III court, in front of a federal court. And the dissent by Justice Sotomayor, was pretty scathing. I mean, what she says is, first that treatment of the public rights doctrine was quote unquote gerrymandered to produce today's result. And then she says, and this is another direct quote, it is not clear what else, if anything, might qualify as a public right, or what is even left of the doctrine after today's opinion. And then she goes on to suggest, look, the majority's opinion can implicate the constitutionality of hundreds of statutes and dozens of agencies with powers to seek civil penalties through administrative proceedings. So, I think she really sounds the alarm bells for what this case could mean, even though, as the case currently stands, it only applied to this one narrow SEC fraud allegation. So, I wanted to do two things next. The next slide discusses what we have here is possible EPA impacts. Obviously the EPA is a federal agency, so with this being a federal decision, these are some of the questions that I thought of, when I was looking at this. So first is, the obvious question. If an EPA claim is linked to a historic cause of action available at common law, maybe this decision applies. Now, clearly it wouldn't apply to permit appeals. Those permit appeals, when if an EPA denies a permit, that would still go through the administrative process. But, what if you have a civil penalty case and, I'm just brainstorming off the top of my head. I mean, a lot of, you know, Clean Water Act type violations, are they grounded in nuisance case law? I mean, are they grounded in negligence case law that is like historic common law doctrines? I'm not sure. I mean, or trespass. I mean, they're all
Mhm.
so I'm sure if the federal, this Supreme Court wanted to make that analogy, they probably would. That's one. Then two, there's some EPA statutes that give the EPA only administrative enforcement authority. So they can't go to the federal court system to try to get civil penalties. One example that I found was the Federal Insecticide, Fungicide, and Rodenticide Act. So under this scenario, if Jakarski was said to apply um, to the EPA or to apply more broadly, you'd need a congressional act to change this law to make it so that the EPA could go to federal courts to do what they need to do for civil penalties. And then, unlike Loper Bright, which Mike discussed a moment ago, this court did not expressly address whether this holding applies retroactively. Um, there's probably not a huge issue because my understanding of the way constitutional law works is generally things are not applied retroactively unless they say they are. Maybe the only sort of caveat to that would be these small subsets of criminal matters, but generally, so this is probably not a big issue, but it's interesting. And then the last thing I'm going to discuss, so that we can move on to another case, but is that what about the states? There's historic Supreme Court case law which the court declined to apply the Seventh Amendment right to a jury trial to the states. But that seminal case is over a century old. So, if this similar issue ever gets revisited by the court, I mean, a century old seminal case, I mean, who knows what would happen. But, in my last slide, what I wanted to mention is, well, how is it going to apply to New Jersey? And I mean, the answer is obviously who knows. I mean, I think as it stands, similar to Loper, this doesn't have a clear, direct avenue to application in New Jersey. But New Jersey has a constitution, of course, and in New Jersey's constitution, there's a right to a jury trial. And it's a very differently worded section than or the Seventh Amendment. There's no discussion of common law or things like that. But if you're Mike and I discussed this yesterday and we were preparing. I mean, if you're a litigant that's defending against a civil penalty claim rendered by the DEP, I would like to think that you'd probably rather have that decided by a jury of people that may not love DEP's enforcement policies versus having it decided by an ALJ that's going to be then reviewed by the DEP commissioner that then is going to go to the appellate division with our version of agency deference. So, I could see somebody trying to use Jakarski to get into New Jersey state court jurisprudence. I don't know. It's a long shot, but I think it's interesting. So with that, I know I meandered on there, Mike, but do you have any
No.
thoughts or comments?
Yeah, no. I think again, the Jarsky, again, sort of discusses sort of this disdain for the administrative state. And I apologize, I didn't realize you had lost control of the slides because I was looking for it. Um, but Gorsuch, in his concurring opinion, really lambasts the administrative process that the SEC has, limitation on discovery, limitation on uh, depositions and subpoenas, the speedy trial perspect. And then there is, and if you appeal it to the the administrator or the secretary, well, your penalties may even go up. So, but then there was uh, I'm looking for it. Okay. And then this, the odds are stacked against you. So in-house, um, according to a study, the SEC won 90% of its contested in-house proceedings compared to 69 of those cases in court. Um, so really sort of that protecting the little person against the big bad government is sort of the theme in this one again. And I think you're right. I think the New Jersey Constitution would provide, whether it flies or not, um, a strong argument to the administrative process doesn't work in New Jersey as well. Um, and I think Sotomayor in her dissent really talks. There's some real practicalities about this. Most cases I think are handled administratively,
Right.
and if we, forget whether the statute provides the right to take it to court by the agency, if we open all these cases up to the courts are understaffed. They have too high of a caseload. Um, is this really going to be chilling of an agency enforcing their regulations? Are we going to overwhelm the court system with all of these cases? And what do the courts do with a influx of cases that they haven't had to decide? Will the agencies decide not to bring cases because they'd have to take it to a court? That would mean additional resources, additional time that wouldn't necessarily occur. And so we're going to see, from at least an environmental perspective, violations go without enforcement just because there's not the resources and the time commitments to bring them,
Yeah.
I
Yeah.
think.
I think you're
Uh,
right.
so I think that will be interesting.
Yeah.
And again, I think will be multiple years of federal case law before we really figure out what this means.
Right. I agree.
And and going back to fix all the statutes that never gave the agencies the ability to go to court. I mean, I cannot necessarily see this Congress doing remedial legislation.
Right.
Maybe they will, but um, all right. Corner Post versus the Board of Governors of the Federal Reserve. This is another interesting one. Um, and I think with Loper Bright really has some huge ramification, at least on the federal perspective. So there was a challenge to Federal Reserve Board regulations that were adopted in 2011 that set maximum interchange fees, how much fees credit cards could charge. So that regulation was adopted in 2011, and the Federal Administrative Procedures Act provided a 6-year statute of limitations. So in 2017, the statute of limitations, the ability to challenge the adoption of those regulations expired. Corner Post became incorporated in 2017, opened in 2018. So again, right around and then right after the statute would have expired, its ability to challenge. Corner Post decided in 2021, so 10 years after these regulations went into effect, to file a lawsuit challenging those regulations. And interestingly, the court said, well, there is a 6-year statute of limitations, but it's not a statute of repose. Statute of repose basically provides, from the date of the enactment for a period of time, that's when you can challenge. But the statute of limitations has additional requirements. And the APA says civil action can be commenced within 6 years after the right first accrues. When is the injury? When is the damage? And so the court noted the injury didn't accrue until after Corner Post was incorporated and fell under the requirements of this regulation. In 2017, it barely existed if it did. So it could not have challenged a regulation that before it existed. It could only have challenged that regulation after it came into existence. So the statute of limitations is, on an agency challenge is really truly a statute of limitations. If you think of a personal injury case, the tort may have occurred, but the actual damage may occur much later, especially maybe in medical malpractice. And so the statute doesn't run until you actually suffer the damage, not when the action took place. And that is what this Supreme Court looked at for challenges to regulations. And again, probably the first time that has ever happened. There's, a concept that, there should be, and it sort of goes against Chevron, some finality. We need to know what the regulations are. We need to know what the law is so we can comply with it. This leaves it open. In New Jersey, we don't have a statute that says this, but we do have a court rule that says appeals from final decisions or actions of the state or the state administrative agency shall be taken within 45 days from the date of the decision or notice of the action taken. So within 45 days of a regulation being published in the New Jersey Register, the clock starts to tick. On the 46th day, your ability to challenge the rules, a facial challenge, ends. So there's a very short period of time under New Jersey court rules for the agency challenge to occur. So New Jersey courts much different. Now court rules, while not super easy to change, are easily, can be changed. It's not a statute. And I think, might correct me if I'm wrong, I don't know that the New Jersey courts want an influx of administrative law cases.
I'm confident they don't. Yeah.
they they are already overburdened, underjudged,
Yeah.
and this would be influx. And I meant to go look, and I don't know what the batting average, so to speak, for administrative decisions are. We sort of have that hybrid. It is outside of the agency, but the commissioner, at least in the case of DEP, are the ones to decide what the average is. How many of those administrative law judges' opinions uphold agency action? How many of those the commissioner reverses or modifies? I don't know, but I think from a practical perspective, the courts would be hard pressed to undertake so many different cases.
Right.
But tying Loper and Corner Post, all of the regulations that we thought were safe because they have been adopted by the federal government for years now theoretically are open for challenge. Theoretically, all I have to do to challenge a regulation that has been in place for a decade is start a subsidiary, start a separate company, go to fill a wetland, go to, undertake some regulated activity. The federal government says you cannot because this is in violation of the regulation. My injury now has occurred, and now I have a 6-year clock starting, and I can challenge it. So, I think that opens up, even though Chevron said this does not overrule all of our decisions and all court opinions that relied on Chevron. Here's your opening to reopen all these Chevron cases for decisions that relied on Chevron. And again, here's an issue where, to the extent that the NJDEP in their regulations relied on the EPA or Army Corps interpretation, here is where those, even though those regulations may have been out there for years, where there may be some challenges may have some impacts. Pretty simple case. I almost say textbook interpretation of the statute of limitations about in an arena that no one thought before. Mike, any thoughts on this one?
I agree with what you said. I mean, it's not this one's pretty straightforward. It's a wild decision in the sense that I forget, and you might have said this. I forget who wrote the dissent, but they were whichever justice it was like this just opens up with to all of these challenges now that Loper just happened. So now you have a situation in which people are going to start challenging regulations, and there's no agency deference like there was before.
Yeah.
And it's so I think it's a very these two back to back are very interesting. Um, but yeah, I think you're right about New Jersey. I don't think I don't think that there is a real impact that I can perceive from this case. Yeah.
I mean, one, there may be those who are going to argue the court should change the rules, but if and Justice Jackson wrote the dissent with Sotomayor and Kagan joining,
Okay.
just to close that loop. All right, this is the case. Didn't come out this year, but uh, came out last year, and I am still very annoyed by this decision. Again, but one, actually, I would say surprising by how far they went on this one. Sackett.
Yeah.
Um,
Um, so I don't, Mike, do you mind when I tell you to
yep,
move this? Yeah,
not
because it was delayed last time, which is why.
not a
So,
problem.
yeah, so look, this is a case, as Mike just mentioned, Sackett versus the EPA. It's the latest version of the saga of the waters of the United States, which, as I'll discuss in a second, is a critical, undefined phrase in the Clean Water Act. It was a 2023 decision by, I believe it was Justice Alito. And I have, if we have time, I got a couple quotes from both the decision and from Rampanos, which I'll talk about in a moment, that are at the very least classic, if not anything else. So just breezing through a little bit of this background, the waters of the United States before the Clean Water Act. So, what was regulated? We had this pre-1900 law, Rivers and Harbors Act, that restricted placement of obstructions in refuse matter that could impede navigation and this was limited to the channels of commerce between interstate navigable waterways. Um, Again, navigation being the key to many of these laws, but particularly the early part of these water type laws, ensuring that navigation wouldn't be impeded. The 1948 pre-EPA, well pre-EPA Federal Pollution Control Act provided that there was federal enforcement through judicial abatement of pollution of interstate waters, required consent of the state where the pollution originated from, But it was like there were very few enforcement actions pursued. It wasn't an overly well-used law. And frankly, the late 40s were a time period when the country didn't care too much about environmental things. I mean, it was before this became a thing, right? I mean, it was obviously a thing, but it became on the public conscience is maybe a better way of putting it. If we can move to the next one. So the Clean Water Act of 1972, um, the answer to Mike's previous question or quiz. It was enacted in 72 with the express purpose to restore and maintain the chemical, physical, and biological integrity of the nation's waters. Um, I think when Mike and I were speaking yesterday, we were talking about how I believe in the narrative for the Clean Water Act. The goal was to have this done by 1983, I think. Or is that it? Or maybe I was thinking of another law. But yeah, and and it again, off topic, but shows how many laws are um, aspirational at best sometimes, and not which makes Loper difficult because it's not always the clear letter of the law is possible. But anyway, the Clean Water Act represented a total restructuring of water regulation. And, among other things, at issue in this case, I'll note that the Clean Water Act requires a permit for the discharge of dredged or fill material into navigable waters. And the term navigable waters, this is the big issue that has come through the Supreme Court multiple times. The term navigable waters means, quote, the waters of the United States, but there's no definition of what the waters of the United States are. So, in 1977, there was an amendment that clarified the state authority to issue permits for discharge to navigable waters, including wetlands adjacent thereto, must be federally delegated. So this sort of the federal delegation part of this, in which I'll talk about later, but New Jersey is federally delegated under the Clean Water Act. If we can move on. So I mean, we could do hours about this, the Clean Water Act and the waters of the United States, but, very briefly, defining the waters of the United States. Um, the EPA and the Army Corps of Engineers are partnered with or they have the task of enforcing the Clean Water Act. Initially, the Army Corps took this very limited interpretation over jurisdiction to traditional navigable waters. Whereas the EPA sort of had this at the outset applied a more broader definition that included wetlands, adjacent wetlands. The Army Corps' interpretation was rejected in federal court, and the Army Corps then issued an interpretation consistent with the EPA's interpretation that applied jurisdiction to include wetlands adjacent to other navigable waters. I should also note, because it's interesting, I think I might have put the site in a later slide. The Migratory Bird Rule, I think it was the Migratory Bird Treaty Act, maybe, proposed to extend jurisdiction to isolated interstate ponds based on ecological benefits, but that was struck down by the Supreme Court more than a few decades ago, I believe. If we can move on. Yeah, here it is right here. So just not going into extreme detail on these, but the history of the waters of the United States. So you have in 1985, in the U.S. versus Riverside Bayview Homes case, the court held that it was reasonable that the waters of the United States include, quote, adjacent wetlands. And then it was understood that wetlands, quote, function as integral parts of the aquatic environment, even though moisture creating wetland does not find its source in the adjacent bodies of water, end quote. And in the Riverside Bayview case, it was required that the wetland, quote, actually abut a navigable waterway. Then we had the migratory bird rule case that I was mentioned a second ago, the Solid Waste Agency of Northern Cook County versus the Army Corps, when the Army Corps sought to extend Clean Water Act jurisdiction to wholly isolated ponds, intrastate ponds. citing ecological concerns because, as we all know, these ponds are extremely important habitats for a number of things, including migratory birds. But the court held that the extension of jurisdiction to ponds that aren't adjacent to open water was unreasonable. So this leads us to, next slide, the Rampanos case. And I hope I'm saying that right, but the Rampanos case was a case in which effectively the Supreme Court was unable to make a decision about what the waters of the United States were. It was a 4-1-4 decision. Um, and nobody really agreed on what happened, what the definition should be. The plurality decision, the one that's listed first in the opinion, is Justice Scalia's decision. He seemed to pen a lot of these environmental case decisions or administrative law ones, which is interesting. But in Rampanos, what his decision was, or his rationale was, that waters of the United States and in turn federal jurisdiction under the Clean Water Act includes adjacent wetlands only when there's a, quote, relatively permanent body of water connected to traditional interstate navigable waters, and they have a continuous surface connection with the water, making it difficult to determine where the water ends and the wetland begins. Surface connection being, one of the, well, there's many, but one of the very controversial parts of this, because as we know, there's a lot of subsurface water connections between many water bodies. So limiting it to surface connections seems, well, at least to me, frankly, unreasonable. Justice Kennedy wrote the concurring opinion, in which he said that waters of the United States include adjacent wetlands if the wetlands either along or in combination with similarly situated lands in the region significantly affect the chemical, physical, and biological integrity of other covered waters more readily understood as navigable. Um, I had to read that 3 times to really understand what that meant. But it's obviously a broader interpretation or inclusion of wetlands in his decision. And I'm not going to read the whole thing because, it's we don't have the time, but Scalia's opinion in Rampanos, it was a good reminder of the way he used to write these opinions and how, he'd just go off on tangents or just really be aggressive in his positions. But he went on to say about the waters of the United States and wetlands that Mr. Rampino, the enforcement proceedings against Mr. Rampino's are a part of the immense expansion of federal regulation of land use that has occurred under the Clean Water Act without any change in the governing statute during the past 5 presidential administrations. In the last 3 decades, the Army Corps and the EPA have interpreted their jurisdiction over the waters of the United States to cover 300 million acres of swampy lands in the U.S., including half of Alaska and an area the size of California in the lower 48 states. And that was just the beginning, as he says. The Corps also asserted jurisdiction over virtually any parcel of land containing a channel or conduit, whether man-made or natural, broad or narrow, permanent or ephemeral, through which rainwater or drainage may occasionally or intermittently flow. On this view, the federally regulated waters of the United States include storm drains, roadside ditches, ripples of sand in the desert that may contain water once a year, and lands that are covered by floodwaters every 100 years. It goes on, but you get the point. It's a just you see Scalia's position on the waters of the United States and the growing regulation thereof. So if we could go to the next slide. Sackett 1, which is the same factual background as Sackett 2, was a U.S. Supreme Court case in 2012. And the bottom line is the Sacketts in 2004 purchased a piece of land in Idaho in which they wanted to build a quote unquote modest home. I'm not sure how modest it really was, but that's neither here nor there. And they began by construction by backfilling their property with dirt and rocks. The EPA showed up and said they were filling federally protected wetlands, issued an administrative order and demand that the wetlands be restored and, included penalties of $40,000 a day. In response, the Sackett sued under the EPA under the Administrative Procedure Act, claiming the wetlands on their property weren't waters of the United States and therefore didn't fall under the jurisdiction of the Clean Water Act. And if we go to the next slide, what ended up happening is the Sackett won. The real question was whether that enforcement action was a final agency action subject to appeal. And the Supreme Court in Sackett 1 found that it was, I think this was also written by Scalia, that it was a final agency action subject to judicial review and on a 9-1 decision. And it was sent back down, remanded back down. And what the result then ended up that Sackett 2, which came back to where we are here, which is uh, Justice Alito this time wrote this decision, and his opinions also, he writes in a somewhat similar manner to Scalia. He actually might have been Scalia's law clerk, if I remember correctly, or maybe it was Rehnquist. I can't remember. It was one of the two, but he wrote um, in his opinion, the Clean Water Act, by all accounts, has been a great success. Before its enactment in 1972, many of the nation's rivers, lakes, and streams were severely polluted, and existing federal legislation had provided to be inadequate. Today, many of these formerly fetid bodies of water are safe for the use and enjoyment of the people of this country. And then he goes on to state, though, however, there is an unfortunate footnote to the success story. The outer boundaries of the Act's geographical reach have been uncertain from the start. The Act applies to the waters of the United States, but what does this phrase mean? Does the term encompass any backyard that is soggy enough for some minimal period of time? Does it reach mudflats, sandflats, wetlands, sloughs, prairie potholes, wet meadows, and playa lakes? How about ditches? What about swimming pools and puddles? So that's how they start Sackett 1. And with that, you can kind of get where this thing's going to go. And that is that um, what ends up happening is essentially the court creates a two-part test. The two-part test includes first a determination of the presence of a water of the United States, and second, a determination of that the wetland has a continuous surface connection with the water, making it difficult to determine where the water ends and the wetland begins. And while this, I guess, is a further expansion or explanation of what wetland is and what's regulated under the Clean Water Act, it seems to me that it's similarly ambiguous. And in fact, Justice Kavanaugh asked this same question himself. Like, how difficult does it have to be to discern the boundary between a water and a wetland? And so now you have a situation in the state of the law and federal jurisprudence is the wetland has to have a continuous, it's not just adjacent, it has to have a continuous surface connection with the water, effectively making it so that you look at a navigable water, a water of the United States, and it's got to be literally connected to a wetland. Whereas you don't really know if you're looking at a water or you're looking at a wetland, and this whole thing is just very confusing. And all we really truly know is that the Supreme Court continues to claw back at what wetlands are regulated under the Clean Water Act. So with that, I guess I should have mentioned the decision. It was 9-1 actually, but it was only because two of the there were two concurring opinions just to the judgment, but not to the actual analysis as to how um, wetlands are regulated. I think it appears that all of the justices, well, I guess not appears, I guess they did, believe that the Sacketts shouldn't have been fined or violated by the EPA, but the definition is what is still at issue. If we could go to the next slide. So the question then becomes, look, the opinion provided immediate relief to the Sacketts, but left the rest of the country uncertain about the impacts, similar to what I just said. But similar to a lot of the cases we discussed today, there's limited impact in New Jersey. New Jersey is a does have a federally delegated wetlands program. I believe we're one of only two states, and I think the other state's Michigan.
Hmm.
Um,
Yep.
we have this robust law, the Freshwater Wetlands Protection Act, that protects wetlands in the state. Um, there are some exceptions. I think I got them all, but I could be. There's certain non-delegable waters that are subject to federal permitting requirements, which are the Delaware River. At least I don't know if it's the whole length of the Delaware or just portions of it, but I know the Delaware, some areas in the Meadowlands, and then Greenwood Lake, which is that lake up in North Jersey that I believe also borders New York, which I got to go to sometimes because I feel like it's always one of the exceptions to these rules, and I've never been there. But so I mean, the impacts again are limited in New Jersey, but they are there. And there may be some more technical impacts that frankly I didn't get an opportunity to dive into. But that's Sackett in a whirlwind discussion. Mike, do you have anything to add about this?
A few things, but before I do that, your second code for us attorneys is 1984. And again, bonus points if you know why I use 1984, 1984. Um, so yeah, I mean, I think again, it's a delegated program. We're one of two states. Michigan was first. We were second. Actually, there was a third, Florida, but that recently got vacated because of endangered species and the failure to use consultation. But I think we are pretty good in New Jersey because of the Freshwater Wetlands Protection Act. There's a couple sort of nuances, and I meant to go back and look, but I believe it is statute required to look at the 1989 manual for the delineation of um, wetlands or any update. So if the feds update the manuals, um, there may be their issue. And then the issue I was trying to noodle through for the last 2 days and haven't quite got there. Under the Clean Water Act, there's Section 401, which is a water quality certification. If um, if there's a federal project or a federal permit being given, the process is to ask the states to give a water quality certification. Will this impact surface water qualities in the state? Um, And there's been some back and forth over the last few years of how expansive that water quality certification and what can be examined or not examined. Um, but it's a trigger if it is impacting the waters of the United States. Um, and so the question I haven't yet to divine, I guess, or determine is, can things that are not waters in the United States are there, if there are wetlands that aren't a wetland or water of the United States, but in New Jersey, does New Jersey's Freshwater Protection Act and its applicability, which is to basically all wetlands, do the impacts to water quality there, can New Jersey deny that water quality certification based upon waters that aren't WOTUS? Pre-Sackett and pre the Trump administration's rollback of the 401, yes, because the state has done that a couple of times. New York State did it and included actually climate change impacts as part of its determination of surface water quality standards. Going forward, I think there might be a question there. Um, but by and large, most of the impacts are going to be these sort of edge cases, I think.
Yeah, I agree.
Uh, and I was looking again, the sort of disdain and sort of this protecting the ordinary person. I could have sworn somewhere in Sackett was the discussion. A person should be able to walk out in their backyard and figure out what is and what is not regulated. Um, And we need to protect the ordinary person who would never in a million years think that was a water of the United States from the big bag overreach of the federal government. Um, and also very interesting. And I also remind people we are taking questions. Please put them in the Q&A portion of the Zoom. We will get to them. Really an ignorance of the science. It is quite clear, the science is super clear that subsurface connections between wetlands and streams and streams um, is very important to water quality, very important to flooding. But the Sackett decision cuts that off. We don't care about the connections subsurfacely and those impacts. What we care about is the surface connection. And wetlands act as a sponge. They absorb water, they slow it down. So water that runs off the land, hits a wetland, will be absorbed, will be slowed down, may travel subsurfacely uh, to streams. And in New Jersey, where flooding is a real issue because we have densely developed and we're experiencing more extreme water events, um, we're SACA to apply in New Jersey and we lose those sponges, we lose those abilities to slow down water because we disconnected waters. Maybe we built a berm between a wetland and a stream. Maybe we put a road between the two, so they are no longer adjacent. SACA would suggest it's no longer a wetland of the United States or water of the United States. Um, and I want to say in the concurring opinion, they said, hey, natural conditions occur. We may create natural berms just by flooding and flow of water. Are they now no longer a water of the United States because nature put up, uh, a natural berm? Um, and again, I think will be a few years before we really understand what continuous surface connections really mean and those reaches. But with that, we're at 124, so we do have a few minutes for questions. If people have questions, please put them in the Q&A. For attorneys, as I'm waiting for some questions, please complete your verification form and put it in there and send it back to us. We will send you a certificate of attendance. Also, I will go, as I'm not seeing any questions. We have a couple additional webinars coming up. We have one on my favorite topic, and I don't know why it's my favorite topic, but it is releasing RSIS's hold on stormwater residential site improvement standards. That is coming up on September 6th. Actually, Mike's colleague, Stuart Lieberman, is going to be one of our panelists. I have invited Senator Swicker, who has legislation to fix this problem, as well as the League of Municipalities to participate. And then we have, and that will have continuing legal education credits available. We have a webinar on daylighting of streams, design and engineering on October 4th. Registration for that one will open shortly, but the RSIS one registration is available. And then we have our Watershed Conference coming up on February 21st on 2025. It is a statewide conference. We were again holding it in the College of New Jersey, where last year, or actually this year, we had Commissioner LaTourette and Senator Smith talking restoration and stormwater and regional approaches. We are looking for session ideas. For more information, click on or scan the QR code and you go to our website. Again, well, I'm not seeing any questions. Mike, any final thoughts?
I guess I'm interested to know, and I haven't been following what environmental cases are coming up the pike. I'm sure there'll be some. I mean, it's the point now, it seems like every term we get at least one. I don't know. But
Yeah, I don't know. Can only imagine what more the Supreme Court will do to the environment. I don't know that we have seen the end of this tension between the separation of powers.
Yeah.
Um, I think the cases we've seen this term really have done some things. Um, and then I debated adding this. There's the major questions doctrine that a couple of years ago the court arguably created out of whole cloth. That if it is um, has a huge economic impact, um,
Right.
or, or would be a super change to how things have happened, and super paraphrasing that last one, Congress would have spoken directly to the issue.
Right.
And if they didn't, the agencies have no authority to undertake. And so think greenhouse gases and climate change. Nowhere in the Clean Air Act does it discuss uh, climate change.
Right.
Talks about air pollutants. Um, so I think there may be a case coming up on that one. I'm sure there's challenges to the administration's response to SACIT, so their new definition of the waters of the United States. I know there are challenges to that. I don't know they've made it up to the Supreme Court yet, um, but they are coming.
Yeah.
And we will be seeing over the years, again, what does SACIT really mean? Um, what deference, what weight does agencies' interpretations have in the federal realm? I think we will have multiple district court and circuit court opinions sort of delving in that out. Do we care at all what the agencies think, or or their decisions they're given some weight but maybe not deference? So I think those will be some interesting things. And then again, seeing how this all plays out in New Jersey, there will be some edge cases, some little tweaks around the edges, I think. Um, so I think
Yeah.
that's it.
I think that's it. I think it was great. Thank you so
Yeah.
much.
Thank you again, Mike. Everyone who attended, thank you very much. Again, our next one is on, oops, September 6th on residential site improvement standards. If people have ideas for webinars and speakers, please reach out to us. We're always looking for additional topics and thoughts. Greatly appreciate everyone's attention and giving us their afternoon. Mike, thank you very much for your expertise and time and discussion on this one. I appreciate it.
Well,
Everyone
thank
have
you.
a good afternoon.
Bye, everybody.
Bye.